Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we will discuss some of the important developments which has happened in the field of Indian polity and that can be important for our examination. So let's start. Here we will be discussing 4 to 5 important topics today. These topics include, first is your Supreme Court upholds the Madarsa Act. Recently, you know that UP's Madarsa Act was in news and the constitutional validity of this particular act was challenged in the Allahabad High Court, and Allahabad High Court has given a verdict saying that this particular act was unconstitutional. Okay, and then in appeal it came in front of Supreme Court and Supreme Court has given the verdict with respect to that and they have upheld the Madarsa Act. We will be talking about that. We will be seeing what kind of rationale has been given. In the previous Polity This Week episode, we have also discussed the Madarsa Act, but in that particular discussion, we have talked about the static part of it. Okay, what are the features of the Madarsa Act and what kind of degrees they are providing. All these things we have discussed. Today we will be discussing that what Supreme Court has given as part of their rationale to uphold this particular law. Okay, after that we will be talking about the election expenditure in India. Recently it was seen that in 2024 election, if we talk about, the per vote expenditure has cost rupees 1400. For a person who has casted his vote, there was a nearly 1400 rupees has been spent on that. Okay, so considering that, if we look at the, you can say, elections, that is 2024 election, it was seen that nearly more than 1 lakh crore rupees has been spent on that. So in that regard, we'll be seeing that how the election expenditure in India is basically being regulated. Okay, so we'll be talking about some legal aspects over there and then we'll be moving to the states formation day. Recently, 1st of November is the day when various state has been formed in different years, but there are various states which has been formed. Okay, so we will be talking about that. We will see what is the procedure of state formation in India, what kind of articles are there with respect to that. So all these things we will be discussing in that. Okay, then redistribution of the private property. Now when we talk about the article 39B, 39C, these are the articles which are there, which are prominently in news again and again with respect to the equitable distribution of resources. Okay, there are various terms which has been used in the article and Supreme Court has taken a particular interpretation of these terms. The question before Supreme Court was that whether the private property can be acquired by the state all the time. Okay, so Supreme Court has given their verdict on that, so we'll be talking about that. Then in the end we'll be talking about the right to privacy case. You must have heard about the 𝐾 Puttaswamy case. Okay, this was in news because recently the Justice 𝐾 Puttaswamy actually died and that is why the, you can say, we have actually discussed this privacy case again. So in this our discussion also we will be going through this particular topic. Okay, so let's start with our discussion. Before that, we are having this GS Foundation courses in Indore and Delhi Center. In Indore, it will be commenced on 13th of November and at Delhi Center, it will be commenced on 26th of November. You can call on this number, that is 8010440440 for any kind of query, or you can directly visit the center to get enrolled. Okay, before moving further, please ensure that you have subscribed the channel so that you can get the important update on your phone. Okay, so let's move further and start with our discussion. Supreme Court upholds Madarsa Act. We have seen in the last discussion that there is this Madarsa Act, and if we talk about the number of madrasas, more than 70% madrasas are there in Uttar Pradesh. Nearly, you can say, this number of regulated madrasas are basically more than 11,000. Okay, so considering that there was this UP Madarsa Act which was there to regulate the education in the madrasas. Okay, then when we talk about this madrasas, they provide two kind of education. One education is basically your religious education which is there. Second is basically your modern education. Okay, now there was question which has been raised with respect to the quality of education, and it was contended that the quality of the modern education is very poor in madrasas, and considering that it is affecting the right to education act, right to education of the child under article 21A of the constitution. Okay, and second thing is that when we talk about madrasas, it was also contended that you can say in the madrasa curriculum, the religious education has been made compulsory and the modern subjects are being made optional. Okay, so considering that, they have said that this is also affecting the the character which we follow, that it is the secularism which we follow in our country, so it is against the principle of secularism. Okay, so these are certain contentions which were there, and considering that this particular act was, you can say, challenged in front of High Court of Allahabad. Okay, and Allahabad High Court has actually you can say said that this particular act is unconstitutional. Okay, and considering that that particular case came in front of Supreme Court, and Supreme Court has actually overruled the Allahabad High Court's judgment, and they have said that this particular you can say law is valid, but they have also struck down some provisions in the law. Okay, now let's see. What is Madarsa Act? We have talked about it. So it is a legal framework for madrasas in Uttar Pradesh, balancing religious and the mainstream education. When we talk about mainstream or the modern education, we are basically talking about the science, arts, etc. Okay. Moving further, established under the Uttar Pradesh Board of Madrasa Education to prepare prescribed the course material. So they have this right. We have this particular board, that is Uttar Pradesh Board of Madrasa Education, and these boards are basically preparing the course material over here. Okay, now it is also conducting the examination. They are also providing degrees. Okay, so that is there. Empowers the state government. When we talk about this particular act, that act is empowering the state government to create rules to regulate the madrasa education. Okay, now that is there. Moving further, you will be seeing that why did Allahabad High Court quash the act? We have already talked about that violation of the secularism. As I told you that the quality of education is not very good with respect to the modern sciences. And second thing is that here this is talking about the religious education. In madrasas, it is alleged that the religious education has been made compulsory. Okay. If you are going for the compulsory religious education, that means that you are trying to go against the, you can say, principle of secularism. That was the argument which was put forward by the petitioners. Okay, so that was one thing, and the Allahabad High Court has accepted this you can say argument. Okay, after that, discrimination in the education. We have seen that the compulsory Islamic education is there and the modern subjects has been made optional. That means that you are not at the equal footing with the students or the, you can say, children which are getting education from the other boards. Okay, so that is one thing. So you can say that there was this kind of discrimination which is there in the education. Okay, violated the right of non-discriminatory quality education under Article 21A, which is talking about right to education. Okay, moving further, conflict with the UGC Act. As I told you, there is this act under which there is a board. Madrasa board is there, and this board is authorized to give degrees like Kamil, Fazil. These degrees are basically the equivalent to your UG and PG degrees. Okay, but the thing is, these degrees are not recognized by UGC. That means that even if you have the degree, you will not be having the recognition. So what is the point of having a degree? So considering that, as per the UGC Act, there are only recognized universities who can give the degree. Okay, so that is why we can say that it is against a central law. Okay, so that was there. So considering all these arguments, Allahabad High Court has struck down the law. Now coming to the Supreme Court. Supreme Court has upheld the act. They have upheld the act, and they have said that you are saying that it is against the principle of secularism, which is a basic structure. Okay, now Supreme Court said that you cannot apply the basic structure doctrine on the ordinary law. Basic structure doctrine will be applied to only constitutional amendment acts, because when Keshwanand Bharti judgment came, it was about the amendability of the constitution, and with respect to that, they have come up with the basic structure doctrine. Okay, now considering that Supreme Court has said that it is only limited to the constitutional amendment acts and not to the normal laws. Okay, so when we are talking about this Madarsa Act is not a constitutional amendment act, it is just a law. Okay, so basic structure doctrine will not be applied over here. So that question with respect to the violating the basic structure, that is your secularism, that does not arise. So that was one thing. Second thing is right to religious education. Now when we are talking about madrasas are providing you religious education, and madrasas are having this authority, or you can say this power, because Article 30 is giving them a right for the religious education. So you cannot say that they are making it compulsory for the religious education, because that is part of their right. Okay, so that is what has been called by the Supreme Court over here. Like minority institutions like madrasa have the right under Article 30 to provide religious education and manage their administration without undue interference. Okay, coming to the next one, regulation permissible. So basically here they are saying that state can regulate such institutions. Here state can regulate education reasonably, including minority institutions, as long as it does not alter their character. If they are not altering the character of a minority institution, they can regulate it. Okay, so that is another thing. And in the end, higher education provision struck down, that is section 9. Section 9 of the Madarsa Act, that was basically talking about the degrees like Kamil and Fazil. And they have said that since these degrees are not recognized under the UGC Act, which is a central act, and you cannot go against the Center's Act, so considering that, the section 9 of the Madarsa Act, that is held unconstitutional. So only this particular section was actually eliminated and the law stays. Okay, even in the observation, Supreme Court, in the last discussion I told you that Supreme Court has said that striking down the whole act will not serve any purpose. Only those particular provisions which are against the law or central's law, that can be struck down. So that is what Supreme Court has done over here. Okay, so I hope that is clear. Now we can move to the next part, that is basically how election expenditure in India is being regulated. Okay, here you can see there is this picture, and which is showing you that from 2004 until 2024 the expenditure has increased. Okay, here estimate is saying that in 2024 it was nearly 1,35,000 crores. This much money has been spent on the elections. Okay, now if you are looking at this particular amount, and they have taken an individual amount in 2019, per person rupees 700 was spent as an expenditure, election expenditure, which has nearly doubled to rupees 1400 in the next election, that is 2024 election. So that means that there is expenditure which is basically increasing, and that is why we are talking about the regulation and how it is being governed in India. Okay, now if we talk about the expenditure, so in India we do not have any limit on the political parties. Political parties can go for the expenditure as much as they want. There is no limit, but there is a limit on the individual candidates. Individual candidates has limit on it. Okay, so we will be seeing what kind of cap individual candidates are having, what kind of restrictions individual candidates are having. Okay, so let's see. Representation of the People Act, that is there with respect to the elections. There are two acts. One is your 1950 Act, and then second is your 1951 Act. Okay, now if you talk about the preparation of the elections, okay, electoral roll, etc., all these part are given in the 1950 Act. Coming to the, you can say, actual happening of the election procedure, so here it is given in the 1951. That is the broad categorization. Exceptions can be there. Okay, anyways, now moving further, here there is a section 77 and 78 which are talking about the, you can say, expenditure by a candidate. Okay, so let's see. Section 77 of the RPA requires candidates to keep a detailed and accurate account of all expenditures. Whatever money he is spending, he should have all the accounts related to their campaigning from the day they file the nomination till the results are being till the elections are happening. Okay, so from the nomination till the election day, you have to keep a track of all the expenditure. Whatever expenditure you are doing, you have to have the accounts of all these things. Once the results patch then once the results are announced, okay, once results are announced, within 1 month of that, or you can say specifically speaking, within 30 days of that, you have to submit the election expense account to the district election officer within 30 days. Okay, so that is what is given in the section 78. First, 77 says that you have to have, or you have to keep the account of all the expenditure from the day of nomination till the day of elections. And then once the results are announced, and after 1 month, you have to, after 30 days, you have to or you can say within 30 days, sorry, not after, within 30 days, you have to submit that expenditure record or the accounts to the district election officer. Okay, I hope that is clear. Then there is this another act, that is Companies Act 2013. Now that is putting a cap on the companies. Okay, domestic companies which are non-governmental companies, they can also go for the funding of the elections. So here you can see non-government company with at least 3 years in the operation may contribute to 7.5 of its 7.5% of its average net profit from the last 3 years to a political party registered under RPA. Now here political party which is registered under RPA, that can get a funding from the companies, and that is 7.5% of its last 3 years average earning. So basically that is a cap which has been put by the government on the funding by the companies. Okay, these companies should be non-governmental companies. Okay, moving further, another law is there, that is Foreign Contribution Regulation Act, that is FCRA. That is the act which was enacted in 2010. Now political party candidates and the election related entities in India are prohibited from receiving foreign contribution. You cannot get foreign contribution from companies or individuals in the form of gift, fund, donation. You cannot have it. Okay, so that is to make sure that you can say any outside entity is not impacting the elections in India. Okay, so that is about the expenditure and regulation. Now what are the impacts here? If we look at the challenges which are associated with the expenditure or governing the expenditure in Indian elections, that is one thing, because we do not have any cap on political parties expenditure. Okay, so we do not have a cap on that. That means that if an individual candidate is filing the nomination, okay, so if he does not have that kind of money, so he will be at a disadvantage. Okay, so that is one thing. Second thing is the parties which are relatively new or regional parties in nature or smaller parties in nature, okay, they would not have such kind of economic or financial backing. Okay, so that might be at the negative, or you can say as the disadvantage. Okay, now absence of regulation. Unlike 65 countries including US, UK, Canada and Brazil, India has no limits on the political party expenditure during the elections. Okay, it leads to uneven playing field, favoring well-funded national parties over the regional and the independent candidates. Now coming to the next one, media advertisement and the disproportionate digital advertising. Now it is an era of social media, and if you are having an edge on the social media, that means that you are creating a wave. Okay, so if you are having money, you can go for the advertisement, and if you are going for the advertisement in the social media, you are creating a hype. Okay, so that will be advantageous to a party who is spending a lot on the digital marketing rather than the party who is smaller and they do not have that kind of fund to spend on the digital marketing. Okay, so that way they are also at the disadvantage. Now the party which is having a national or the state level presence, or the they are going for the media presence, etc. So they will not be spending more on the rallies or the ground level work. They will be going for the creating a hype at the social media or the media. So that is how you can say that is also somehow disadvantageous to the state level or the regional parties or the individual candidates. Okay, this trend exhibits the existing inequalities, reduce the visibility of the smaller parties and the candidates. So these are the challenges with respect to the election funding. Okay, now we can move further to the next topic, that is talking about the state formation day. 1st of November. Various you can say years, 1956 was there, 1966 was there, 1965 was there. These are certain years where various reorganizations has happened and various states has actually were created. So we can say that is the day which is celebrated as the state formation day. Okay, now here you can see what are the constitutional provisions related to the formation of the states. Now how states are created in India, we will be talking about what kind of state has been created in the November. So but before that I would like to tell you that how states are created in India. Okay, so article 2, we know that first article is talking about India, that is Bharat shall be a union of state. Then article 2 is it empowers the parliament to admit into the Union of India or establish new states on such terms and conditions as it thinks fit. That means that parliament has power to admit or create a new state. Okay, that is one thing. Second thing is It relates to the changes in the existing states of the Union of India. It deals with the internal readjustment between the territories of the constituent states. So basically, within the union, parliament has power to go for the readjustment and create new states. Okay, so in that regard, they can go for the increasing the area, decreasing the area, that can be done. Okay, it authorized parliament to form a new state by separation of the territory from any state or by uniting two or more states. Example is formation of Telangana from Andhra Pradesh and Jharkhand from Bihar. So wherein from a larger state, particular territory was excluded and that territory was made a new state. Okay, moving further, it can increase, diminish, alter the area of any state and boundaries or the name of any state, like alteration of the area and the name of UP, MP and Karnataka. Okay, from Uttar Pradesh we have created Uttarakhand, from Madhya Pradesh we have created Chhattisgarh. Okay, so that is what the power has been given to the parliament. Okay, now what can be the procedure? There are two conditions in this regard. Now for that you have to pass a bill in the parliament. Okay, so here you can see a bill for this can be introduced in the parliament only with the prior recommendation of the president. Okay, so that is one thing. President can refer the same to the constituent state and they can take the opinion of the state, but that opinion is not binding. Okay, the president has to refer the same to the state legislature for the expressing the views within a specified period, though the president or the parliament is not bound by the views of the state legislature. Okay, in the case of the union territory, no reference need to be made because all that are administered by the, you can say, president himself. Okay, so that is basically how you are creating a new state. Now if we talk about the states which has been created during in the November. Okay, so here you can see these are the states: Andhra Pradesh, Karnataka, Haryana, Kerala, Punjab, Chhattisgarh and Madhya Pradesh. These are the states which has been created in November. And when we talk about the Andhra Pradesh, it was created in 1956. Before that, you must be, somewhere it will be written that Andhra state was created in 1953. So you can, that was also right. That was Andhra Rajya. Andhra Rajya or Andhra state was created, but Andhra Pradesh was created in 1956. Okay. After that, when we talk about the Madhya Pradesh, Karnataka, Madhya Pradesh and Kerala, these three states were created in 1956. Okay, sorry, 1965. These were created in 1965. Okay, then we have other states like Punjab and Haryana. They were created in 1966. Punjab and Haryana, they were created in 1966. Okay, and when we talk about Chhattisgarh, that is 2000. And there are Pondicherry and Lakshadweep, the union territories which are given over here. So Andaman, Nicobar, Andaman, Nicobar, Delhi, Lakshadweep, these were created in 1956. Okay, and Pondicherry, that was created in 1954. And when we talk about Chandigarh, that was also created in 1966. So you can see that Haryana, Punjab and Chandigarh, they were created in 1966. Okay, you don't have to remember all the, you can say, these particular years. Okay, but few important, if there is something which has been in the news, then you have to keep a note on that. Okay, anyways, we can move further over here. These are the reorganization of states which has happened, how it has happened, what kind of you can say states were there before the first reorganization. So earlier we had 4 categories: part A, part B, part C and part D, and after that there was 14 states which has been created later on. So that is what 14 states and 6 union territories that were created with the 1956 reorganization. And if we talk about today's situation, we have 28 states and 8 union territories. Okay, so these are the data you should remember. Other than that, when was a particular state was formed, that is given over here and here. Okay, so you can either take a screenshot or we will be sharing the PDF. Okay, now we can move further to the next one, that is redistribution of private property. Now this particular topic was in news because Supreme Court has given a verdict on that, and Supreme Court has that all kind of private property cannot be taken by the state. Okay, there are some properties which are basically forming the material resources of community. Okay, the property which is forming material resource of the community that can be taken by the state after giving a compensation, but not all kind of private property will be taken by the state in the name of the redistribution. Okay, now why all these issues has started, we will be seeing that. First we will be talking about certain things over here. See, Supreme Court verdict. The Supreme Court in 9-judge bench ruling held that the government cannot acquire or redistribute all private property, own property, simply deeming them as the material resource for the community under Article 39B. Okay, now they have said that every private property is not a material resource of the community. You have to make a distinction. Why? Because let's say if they wanted to you can say include all kind of private property, they would have simply wrote the material resource. They simply would have wrote material resource in the article, and no need to writing of this particular term, that is of the community. Okay, that is one thing. Second thing is, if they had to exclude all the private property, they would have wrote material resource of state, of the state. That means that here, if they wanted to keep public property under Article 39B or C, they would have wrote the state. If they wanted to have the both public as well as private property, then they would have wrote simply the material resource. Okay, but they have wrote a term that is material resource of the community. That means that they have created a distinction between the community's resources, individual resources, and the public resources. Okay, so considering that all kind of private property cannot be acquired by the state. Okay, so that is what has been given order that has been given by the Supreme Court. The decision reinforced the property rights and the limitation of the state's intervention. So basically, they have put a cap or the restriction on the state's intervention in acquiring the private property. Now let's see what we can actually gather out of that. Article 31C's validity. Supreme Court has said that they have examined whether the Article 31C, which protects the law aimed at redistribution of the resources from the common good under the Article 39B and C, still holds after the amendment and judicial scrutiny. Okay, so basically what is happening over here is that we have Article 39B and C. These are the articles which are focusing on the redistribution of resources and to avoid the concentration of wealth. Okay, so considering that earlier government can go for the acquisition of the property. So in 1969, here if we see, so what has happened in 1969, we know that there was this nationalization which has happened, nationalization of the resources which has happened, and that has happened under Article 39B and C, saying that they are going for the redistribution. So industry was nationalized over there. Now this particular, you can say, step was challenged in Supreme Court, and Supreme Court has said that this is unconstitutional. Okay, this is unconstitutional because it is violating Article 14, that is equality, Article 19, that is basically your freedom of going for any kind of profession, and then Article 31, that is right to property. Okay, right to personal property. So you are violating that. So to make sure that this particular step was legalized, government has gone for the Constitution amendment. Okay, and they have amended the Constitution, and they have said that if government is making any law to enforce the DPSP under Article 39B and C, that cannot be challenged in the court of law. Okay, so that is what the amendment has been brought for the redistribution and the avoiding the concentration of wealth. If they are making any law to enforce Article 39B and C, that will not be questioned in the court of law for the violation of the fundamental right. Okay, fine. Then in 1973, in the 𝐏𝐤𝐻 𝐏𝐫𝐞𝐥𝐢 judgment, they have said that okay, fine, you can amend the, you can say, fundamental rights, but you cannot violate the, you can say, the basic structure. Over there, the Supreme Court has reaffirmed that if the law is there which is made to enforce these DPSP under Article 39B and C, so in that case this will prevail and you cannot challenge the law with respect to the violation of the fundamental right. Okay, but later on in 42nd Constitutional Amendment Act, government has thought that we can do this, then we can do it for all the DPSP. So they have said that for all the DPSP, if we are making any law, you cannot challenge it for the violation of the fundamental right in the court of law. Supreme Court has said that no, you cannot do that. Only for this particular, you can say, this particular DPSP, which are given under Article 39B and C, you can say that you cannot be challenged in the court of law for the violation of fundamental right, but not for all the, you can say, DPSPs. So right now, what is the position? Position is that 39B and C, which are given, that particular provision which is mentioned under 31C, that is, you cannot challenge a law which is to enforce 39B and C in the court of law for the violation of fundamental rights, because this will prevail over the fundamental rights. So that is the position, and this position was reiterated by the court in this particular judgment. Okay, so Article 31C's validity was upheld again. Okay, so that is one thing. Then they have restored the post Kezhavanand Bharti position, which we have already seen that in the Kezhavanand Bharti they have said that for this you cannot challenge the, you can say, law in the court of law. Okay, now moving further, interpretation of the Article 39B, addressing whether private property can be considered material resource of the community or not. Okay, so in this particular case, Supreme Court has said that not all the private property can be considered as the material resource of law. Okay, so you have to make sure that there is some kind of public interest which is attached to it, and only for that you can go for it. Okay, then Supreme Court has that all the private property should not automatically be equated with the resource for the community use. Okay, so that is there, and they have diverged from previous position which has been given in the state of Karnataka versus Sri Ranganath Reddy. In that it was said that all the private property can be acquired by the state if state want to do it. Okay, so they have changed that particular stance and they have kept that. Finally, right now, what is the position? That you cannot take away all the private property under the term that is your material resource of the community. Okay, so that is what has been talked about by the Supreme Court in this particular verdict. Okay, before moving further, I would like to tell you the, you can say, crux of this. So ultimately, when we are talking about the private property, not all private property can be acquired by the state. Okay, so that is the position. Now, moving further to the next one and the last one, that is right to privacy case. So recently, as I told you, that there was this person 𝐏𝐻𝐒 𝐏𝐫𝐞𝐥𝐢𝐬 and he died recently, and that is, he was the person behind the right to privacy being a fundamental right. Okay, so let's see what was the case here. Supreme Court ruling on the right to privacy 2017. This is, you can say, recent judgment which is there. Generally understood that the privacy is synonymous with the right to be left alone. Okay, then the Supreme Court described the privacy and its importance in the landmark decision of K.S. Puttaswamy versus Union of India in 2017, which is the case that is we are discussing right now. And a nine-judge bench unanimously ruled that the right to privacy is an intrinsic part of the right to life and personal liberty under Article 21. Now, after K.P. Puttaswamy, the position is that right to privacy is basically a fundamental right under Article 21 of the Constitution, that is talking about right to personal, right to life and personal liberty. Okay, and under this personal liberty you have this, you can say, right to privacy as well. Okay, recognized as a fundamental right and part of the freedom guaranteed under Part 3 of the Constitution. Here you can say the government argued that the privacy was not a fundamental right, citing the previous ruling. There was this previous ruling, that is MP Sharma versus Khadak Singh case. In that it was maintained that right to privacy is not a fundamental right. But Supreme Court has actually overruled this judgment and they have said that the right to privacy is a fundamental right. Okay, so the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 as part of the freedom guarantees under Part 3 of the Constitution. Puttaswamy judgment hold the right to privacy is protected as a fundamental constitutional right under Article 14, 19 and 21. We are saying that this is part of Article 21, that is explicitly which has been mentioned by the Supreme Court in the judgment, but you can say that it is also under Article 14 and 19, you can see that it right to privacy is a fundamental right. Okay, now moving further, privacy principle explored by the Supreme Court. Over here you can say Supreme Court connected the privacy to principles like autonomy, dignity and the personal identity, shaping rights related to the self-expression, equality and the non-discrimination. So basically a person would decide for themselves that what he wants to share and what he does not want to share. Okay. Then significance of the privacy as a fundamental right. You can see the Supreme Court emphasized that the constitutional right like privacy is shielded from any kind of overriding power by the state, by any kind of popular opinion or the legislation. So basically you cannot override the right to privacy by popular opinions or the legislation. So basically that is what a fundamental right is. Okay. Overturned past ruling that did not recognize the privacy as the fundamental right, which we have already seen. That was your MP Sharma and the Khadak Singh case. Okay, so that is the right to privacy. That was just a simple, you can say, passing reference which we have to give you because that was in the news. Okay, now we can move to the next part, that is test. There will be 5 questions which will be asked to you and you have to answer to me in the comment box. So Right to Education Act mandates free and compulsory education for children aged 3 to 10 years, 6 to 14 years, 8 to 15 years and 10 to 16 years. Okay, moving further, question number 2. Which amendment removed the right to property as a fundamental right? 44th Amendment, 42nd Amendment, 86th Amendment and 74th Amendment. Okay. Then next is the landmark case in which the Supreme Court of India declared the right to privacy as the fundamental right under Article 21 was Keshwanand Bharti versus State of Kerala, Indira Nehru Gandhi versus Raj Ryan, Puttaswamy versus Union of India, or Minerva Mills versus Union of India. Okay. Then we have State Reorganization Day is primarily celebrated to commemorate the formation of the states based on cultural factor, linguistic boundaries, economic potential and population size. Okay, so with that we will be wrapping up the discussion. You can attend all these questions and answer to me in the comment box. With that I would like to take your leave, and if you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.